Well, let's first define our terms. When someone files a bankruptcy petition, the act of filing the petition triggers a stay. What is a stay? In law, stay says stop. Whatever stayed has to stop. And in this case, you don't have to do anything other than just file that bankruptcy petition. So it's called the automatic stay. Well, what does it stay? It stays all action by creditors against the debtor, against the debtor's possessions, and against the bankruptcy estate that's created when the debtor files that bankruptcy petition. In practical terms, it means that the creditors can't call the debtor on the telephone, send them bills, write letters, sue, garnish wages, seize money out of bank accounts, foreclose on property, or repossess property. In essence, what it does is it erects a legal brick wall around the debtor to protect him or her from the depredations of the creditors. So that's a pretty extreme bit of relief there. And from the creditor's perspective, that's a little bit of a hard hit. Because of that, Congress has seen fit in its extremely finite wisdom to include some carve-outs on the automatic stay. For example, if there are criminal proceedings against the debtor, then those are not stayed. Or if there is some sort of dissolution action taking place, to the extent that it involves things like questions of paternity or the actual dissolution, that's not stayed. However, the division of assets, that is stayed. There's a fairly lengthy list of these carve-outs that you can find in Section 362B of the Bankruptcy Code. So if you're a creditor and you see that a debtor has filed this bankruptcy case that's triggered the automatic stay, do not take any actions against the debtor, because if you do, the debtor can sue you in a bankruptcy court, and if the debtor is successful, not only can the debtor get damages out of you, but also costs and attorney's fees, which is somewhat unusual in the American system unless there's an enabling statute, which there is in this case. Well, why would a creditor want the stay removed? And a creditor can ask the bankruptcy judge to lift the stay for some limited purpose. The way the creditor does that is by filing something called a motion for relief from the automatic stay, asking the judge to lift the stay for a limited purpose. So let's take a look at a couple of situations in which this may happen. For example, let's say the debtor in the bankruptcy papers, in a document called the Statement of Intention, has said, I can't keep this car, I'm going to surrender it as part of the bankruptcy. That way, the money that I still owe will be discharged at the completion of the bankruptcy case. I won't have the car anymore, but I won't have the debt anymore. The debtor might choose to do this, for example, if the car payments are simply too high. There's been a change of circumstances that has rendered the debtor unable to make these payments. Well, the creditor would like to come and repossess the car, but the creditor cannot do so while the automatic stay is in place, because that is an attempt to collect against an antecedent debt, to collect the collateral. So there's a situation in which the creditor will say, would you please lift the stay, Your Honor, so that we can go after this vehicle? After all, the debtor has already said, I'm going to surrender it. So no harm, no foul. And in a situation like that, if I'm representing the debtor, we're not going to take any action, and the judge will, just as a matter of course, lift the stay. But just for that limited purpose of allowing the creditor to go retrieve the car. That won't include lifting the stay so that creditors can come and garnish wages, for example. Another situation that sometimes arises is prior to filing the bankruptcy petition, a creditor is suing the debtor in state court. Here we're in California, so that would be the California Superior Court. And let's say the creditor is interested in collecting against an insurance policy, really isn't interested in suing the debtor personally, but only to the extent that there is an umbilical cord between the debtor and insurance coverage. Well, the creditor can't continue the lawsuit because the automatic stay has stayed. So the creditor might go to the bankruptcy court and ask the judge to lift the stay for the limited purpose of being able to go and prosecute that lawsuit to its conclusion. And of course, if the creditor wins, to be able to collect against the insurance policy. In a situation like that, the debtor really has no dog in the fight, if I can use somewhat vulgar language here. Might as well just let the creditor have at it, because if the creditor in the motion for relief from stay says, we're not going to try and collect against the debtor, we just want to go against the insurance company. Well, there's another motion for relief from stay that's really going to be non-controversial. Things get a little bit trickier when you've got a situation where, let's say, the creditor was foreclosing on a piece of real estate. Well, real estate can have a lot of value and a lot of equity. Equity here being defined as the fair market value of the real estate minus the various encumbrances against that property. Well, foreclosure is just about to take place and the debtor files a bankruptcy petition. That stops the foreclosure sale dead in its tracks. So the creditor might wish to have the stay lifted so that it can resurrect that foreclosure proceeding and sell the property. And now we get into, it depends on which chapter. If it's a Chapter 7, well, the Chapter 7 trustee appointed by the bankruptcy court to the case might say, Your Honor, this asset may be valuable to the bankruptcy estate. We would like to keep it in the estate for possible liquidation to pay creditors. So the creditor might have a bit of a fight. And since Chapter 7 cases usually don't last very long, for most creditors, the better part of wisdom is just to sit it out. We're not going to file our motion for relief from stay. In 5 or 6 months, the debtor will get a discharge, the court will close the case, and we'll just pick up where we left off. So that is really on a case-by-case basis, and it depends on what the incentives are or disincentives, as the case may be, for the creditor. This is a somewhat vast subject, and we've only just scratched the surface. So if you do have questions about the automatic stay, you can always give me a call at 562-777-9159. But please remember that I'm licensed to practice in the Central District of California. So if you're calling from Michigan, I'm not going to be able to talk to you about this. Now, I am licensed to practice throughout all of California, but my practice is in the Central District of California. So again, if you're from Michigan, and I have had calls from various places around the country, I can't give you legal advice if you're not a California resident.